Hello, everyone. This is Michael Ball. I'm joined by my partner, Jennifer Dunsizer, who unfortunately is a little under the weather and has lost her voice to some extent. So I'll take care of just kind of walking through the preliminary stuff. We're here to discuss employment and severance agreements and how to avoid hidden traps and kind of recent updates and matters of significance in regard to the agreements, as well as kind of key restrictive covenants that may be included in such agreements. So if we walk through kind of the anatomy of an employment agreement, first we want to spell out the employee's duties. We want to discuss, to varying extents, current compensation and benefits, as well as compensation at the termination of employment, and any post-termination covenants, which could include agreements to arbitrate, confidentiality agreements, non-compete agreements, non-disparagement, non-solicitation clauses, as well as some other options. And with regard to duties and compensation, for duties, it's important to have an accurate description of an employee's duties contained within the employment agreement. And the purpose of that is because oftentimes post-employment covenants may restrict the employee's abilities to perform those same duties for a competitor. And therefore, it's important that the duties are accurately described in the employment agreement so that the correct duties are being foreclosed in future employment. One issue we come across is that an employee may sign an employment agreement, and the employment agreement may either inaccurately or incompletely characterize the employee's duties, or it may accurately describe the duties. However, at the time that the employee is terminated, they may be 1, 2, 3, 4 jobs down the line, such that their duties are now completely different than they were at the time they executed their initial employment agreement. So the non-compete that employee signed may prohibit them from doing duties that are entirely different from what the employee is currently doing and what we would have an interest in restricting their ability to do for someone else. So we think it's important to have a process in place to update those job duties as reflected in the employment agreement to evolve so that any post-termination covenants remain appropriate and of the maximum potential benefit to the employer. Then another consideration is how much to document specific compensation and benefits in the employment agreement. Typically, we'll have clients include the minimum salary and then discuss, other potential benefits that the company offers to similar employees or employees of a similar classification. Oftentimes, employees kind of think they're getting more security and want each individual benefit to be spelled out in the contract. Oftentimes, that can be problematic because many of those benefits are given at the discretion of the company. Those benefits often change, as the company changes moving forward. And so it can be problematic to have, different benefits promised to different employees based on, kind of what that employee wanted to be included in their employment agreement. So we would propose, a uniform approach and one that maximizes the discretion of the company and their ability to change benefit packages as necessary to suit the needs of the business. One kind of key issue historically, a standard interview question would be, what are you currently making, or what did you make at your last job? And employers found that information helpful so that they could offer a compensation and benefit structure that was competitive and enticing to the employee to get them to come, but then at the same time, not overpaying or paying significantly more than would have been required to get that individual. And there have been studies that the Department of Labor commissioned, and the EEOC has been looking into this kind of hot button issue for a while, and they've taken the view that such questions kind of further the wage gap by basing an employee's pay, at least in part, on their previous salaries, where those salaries may have been artificially low or dependent on systematic discrimination that wasn't paying that employee market rate or what they were essentially worth. And so to break this pattern or this trend, many states and locales have instituted restrictions on an employer's ability to ask about prior compensation, or even to use that information in the event it is an internal candidate that they already know their past compensation, or some states, for California, for instance, has put in the law prohibiting an employer from using prior salary information even if the applicant volunteers it. So there are varying levels of what may and may not be considered. However, employer needs to be up to date and knowledgeable of the various state requirements, and kind of as a general trend needs to understand that moving forward, these bans on prior compensation are becoming more widespread. They are becoming more popular, and kind of think like the ban the box trend of the past that prohibited employers from asking about prior criminal convictions. These are spreading, and moving forward, kind of a best practice for interviewing potential candidates would be to exclude questions regarding past compensation to avoid any potential discrimination claim on that front.
Thanks, Mike. I'm now going to talk about one of the concerns when you write in a specific benefit is that you may end up creating a special benefit that's not covered, for example, by the insurer policies. So if you promise somebody a particular benefit and the insurance is only going to cover active employees, but you say you can continue on the life insurance coverage for a year after you terminate employment, suddenly you've got a benefit that you have promised that the insurer has not promised to pay for. And what you end up then is court cases that have almost universally found that the employer is bound by the promise in the contract, and so they're required to provide the benefit, but the insurance company is not required to pay for it. And so you have self-insured a very expensive benefit for employees without the offsetting insurance coverage to pay for it. In addition, there are benefits that only get a tax advantage if the benefit is provided on a non-discriminatory basis. And if you are, generally speaking, the people who get employment agreements are your executives, if you're only giving an employment agreement to your executives, which will be your more highly compensated employees, and you've given them a benefit that you don't give employees generally, you may have created a tax problem. And then the last is, to the extent that you are providing a benefit that's a medical, dental, vision, life, disability, or severance benefit, those plans, even if they're just to one employee, is an ERISA plan. And so if it's an ERISA plan, you've got reporting and disclosure requirements unless we can fit it into an exception. And there are a number of times we have found employers who have not gone through the steps necessary to make their one-off arrangement an exempt ERISA plan. So we need to make sure that we've gone through that analysis and it fits in an exception, and if it doesn't fit in an exception, that we comply. I talked about some tax problems. One of the tax problems, in particular with discriminatory medical benefits, is that self-insured benefits that discriminate in favor of highly compensated employees, the benefit payment is taxable to that highly compensated employee. So a person gets hit by a bus, has $1 million in medical claims, suddenly they have a huge tax bill, and so you need to make sure that if you're going to provide it on a discriminatory basis, for example, that we tax the employee on the premium value of that insurance, and that if the premium has been taxed, the benefit is not taxable. If the benefit is taxable, it also causes a problem under 409 Cap A. As you may know, 409 Cap A is an Internal Revenue Code section that charges an excise tax on benefits that don't comply with the requirements. And if you've got an expense reimbursement that doesn't have the expense reimbursement language in it, and the benefit was taxable, suddenly I've got a non-compliant benefit under 409 Cap A, and again, all of those dollars that are paid are going to be taxable to the employee, plus a 20% excise tax, so a generally bad result. The next thing we're going to talk about is when does a separation from service occur? And as a general rule, 409 Cap A has a facts and circumstances test that defines when a person has had a separation from service that triggers payment. And you can't just call a person still an active employee and delay the payment of benefits that are triggered off of severance. You have to pay it based on when the person actually has their termination. And so, you know, the Brits refer to this as a garden leave. I can't put you on a leave and say, go sit in your garden and leave us alone. You can't use that structure and delay payment. And similarly, you might not be able to pay severance to someone who's still working for you on a part-time schedule or is working for you as an independent contractor. The person has to actually have stopped working for you enough. And so if they're working more than really 1 day a week, you're going to have to go through a facts and circumstances analysis. Once we talk about when does somebody terminate, the timing of severance payments is the next big thing that the agreements address. And that, first of all, starts with if payments are going to be made within 2 years and are less than 2 times pay in total, we can structure that benefit as a welfare benefit rather than a retirement plan. And the reason that that's important is, again, from an ERISA perspective, retirement plans have vesting requirements. So to the extent that you need, someone needs to have vesting, we need to have a, the vesting and non-discrimination provisions, because it's a retirement plan, we need to make sure it's, again, limited only to a select group of highly compensated employees so that we can fit within the ERISA top hat exception from a retirement plan. But we couldn't have a retirement program that covered sort of everybody that was a ERISA retirement plan, because that would be a problem, because it wouldn't, it probably wouldn't meet the vesting and non-discrimination requirements. In addition, if the company is a publicly traded employer, no payments can be made to a specified employee during the first 6 months after their separation from service. So we've got some limitations on when benefits can get paid that are based on. The next thing I wanted to mention briefly is this substitution issue. And to the extent a benefit is deferred compensation, the rule is that you can't substitute a benefit that has a different payment timing than the original payment. So often you'll have in your agreement, you'll have a payment that, you know, gives you a different benefit for someone who is, you know, would normally have received payment X, but we're going to accelerate payment, pay you in a lump sum because we want to be done with you and you want to be done with us. That would be a problem. It would be an impermissible acceleration that would trigger immediate income tax inclusion plus the 20% excise tax. So that would be the definition of a bad thing to do. Okay, so now we're going to talk about, in your severance part of your employment agreement, or the severance agreement, if you don't have any of the current employment terms and you just talk about severance in your agreement, the first thing is, what do you want as your payment trigger? And the most common thing that you'll say is you don't get severance if you're terminated for cause. And then the definition of what is cause is one of the areas that people focus. And there's a tension between protecting the company and being employee friendly. Some companies are adding cause triggers that forfeit the severance benefit if you have if you do something that causes reputational harm to the company, and that even includes reputational harm for stuff you did at your prior company. So you hire a new CEO, there are allegations that come out after you hire them that there are all these lawsuits that are being filed about sexual harassment at their prior employer. Can you fire them because of those bad acts are tainting the view of them as your CEO, and so you want to terminate them for cause and not give them any severance. And speaking of sexual harassment, some companies are specifically adding a sexual harassment trigger and not just relying on the compliance with company policies trigger. The second most common definition of a severance trigger is a good reason quit. The person quits, but it's really sort of a constructive discharge type claim that you made certain changes to their position, and the person objects to that. You don't recant the changes to their position after they complain, and then they get to quit and still get the severance benefit. To fit under the 409 Cap A's good reason definition, you have sort of limited types of changes that you can make that are the good reason triggers, and you do have to provide this opportunity to cure before the person quits. The next two triggers that you frequently see in employment agreements is death and disability. And these are two things that you want to think about carefully before you add, because you currently already provide, for most companies, a life insurance benefit and a long-term disability insurance benefit. And so paying a severance benefit on top of those may end up shifting cost from the insurance company back to you, because frequently insurance companies will offset amounts that the person receives from the employer from the benefits that are due for disability benefits. And for the life insurance benefits, again, it might end up creating a windfall to the employer or to the employees. So we frequently don't see disability and death benefits included, and if it is included, typically it's offset by the company-provided benefits. So it's providing sort of a guaranteed level of benefit on the death and disability, and if you get a company-paid benefit that's richer than that severance benefit, then the company would pay zero. Just one other thing on the disability and death. If you do have a payment that you're going to make that's with an offset, you want to make sure that the insurance policies won't offset your payment, so you effectively shift, again, the full benefit that was supposed to be insured to the company, and you're only providing that sliver that's on top. To the extent that the next trigger you frequently see is a change in control trigger. And the first thing you have to think about is what kinds of change in control are going to trigger that benefit. And we frequently find employers that have different agreements that have different definitions in them. And that means that a transaction might be a trigger for one benefit but not for another. And that's really confusing to employees. So we recommend that you try to standardize whenever possible. And to the extent that the change in control is a payment trigger on its own, it needs to be a 409 Cap A compliant change in control definition. We frequently see lots of definitions that aren't a 409 Cap A compliant change in control, and that's not a problem if it's a double trigger. If the payment's made only if you terminate employment within a specific period of time after the date of the change in control, because then the termination is the payment trigger, and that's a good 409 Cap A payment trigger. If it's a single trigger, or if the change in control changes the payment from a payment that was going to be made over a period of time to a payment that's made in a lump sum, for example, so that there's a change to the timing of payment, then the 409 Cap A definition needs to be compliant. So that's an important, again, an important nuance as you're looking at your definitions to make sure that you've gone through those. Okay, now I've gone through the common payment triggers for your change in control provision, or for your severance benefits. And the next thing I want to talk about is, are you going to require a release as part of the payment, or as part of the consideration that you're getting as the employer? And from a company perspective, you're paying a lot of money for severance benefit. Getting a release of claims against the company is a good use of the company resources. It ensures that you've not just funded a lawsuit against you. But there are certain kinds of claims that cannot be released, or can only be released with certain disclosures. And then there's also a timing provision that if a release is required and the amount of time a person would have to consider the release spans 2 tax years, then no payment can be made until the second tax year. So it impacts again, the language that you have in the release. You can't say, we're going to pay you within 2 weeks after severance if you've got a release requirement, or we're going to pay you as soon as the release becomes irrevocable. You have to make sure you've folded in this timing exception. Okay. Now we've talked about when it's triggered, whether or not you're asking for release. The next big issue that you have in the severance benefit piece is, okay, so how much can I pay? And what kinds of benefits do I pay? And the most common benefit is a salary continuation payment that's either paid at your regular pay schedule cadence or in a lump sum. And the most common multiplier is 1 year of pay, or 2 weeks of pay for every year of service, are the 2 most common formulas. CEOs sometimes get more as part of their severance. A second question was with regard to bonuses. Do you guarantee a particular level of bonus? And then the next one is, do you provide some benefit continuation provision? As a general rule, you generally want to pay a benefit that is provided on a subsidized basis for your executives. That's not provided for other employees, but to the extent, so you need to be careful about that. Okay, so another benefit that you'll frequently see, sorry about that, is accelerated vesting of your equity benefit. And then sometimes people will ask for, I want to keep my laptop, I want to keep my company car, I want to keep whatever, and so other stuff being thrown in. To the extent that what you're talking about is severance that's in connection with a change in control, there are 2 code sections that limit how much you can provide to somebody. And it is considered bad form from a shareholder relations perspective to pay a benefit that is greater than can be provided without triggering these adverse tax consequences. There's a tax consequence on the company under 280G that imposes an excise, or that limits the company's tax deduction, or a similar tax on severance benefits that are paid by a nonprofit company under 4960. And then there is a 20% excise tax on the employee under Code Section 4999. This tax gets, and the loss of deduction is triggered if the present value of payments exceeds 3 times the base amount, which is based on the person's Box 1 W-2 wages for the 5 years before the change in control. And so obviously where people are having wage increases over time, I couldn't necessarily pay a benefit that's 2.99 times current base pay plus your current bonus or target bonus, because that's typically going to exceed that 3 times number. So you've got to do an evaluation of whether or not the cutback is going to provide. Most agreements do have a cutback, but that is very unpopular with employees for obvious reasons. They think they were promised a much richer benefit and they're unhappy when they don't get it. Now I'm going to turn it over to Mike to talk about post-termination covenants.
All right. So we want to discuss kind of key restrictive covenants. Restrictive covenant is a contract between the employer and the employee that restricts their rights. And so, we have restrictive covenants that restrict an employee's ability to file a lawsuit in court, restrict an employee's ability to subsequently compete with their former employer, restrict their ability to disclose confidential information, to solicit clients or employees of the former employer, or to make disparaging remarks about the former employer. And specifically, kind of the hot issue, or the one that employer needs to take the most care when drafting, relates to agreements not to compete. So restrictive covenants limiting an employee's ability to compete with that former employer, following their employment. So first I wanted to talk about arbitration agreements. And arbitration agreements have been around for a long time. However, they've really kind of come to the forefront in the last few years as class and collective action waivers contained within arbitration agreements were challenged, and the validity of that waiver was heard and decided by the Supreme Court in this Epic Systems case. And the legal argument that the plaintiffs brought was that a restriction on their ability to pursue a class or collective action runs afoul of the National Labor Relations Act, which guarantees their ability to concerted protected activity. And in addition, they raised the argument that the Fair Labor Standards Act permitted collective action, and that a arbitration agreement limiting their ability to do that runs afoul of the Fair Labor Standards Act. The court, in a close 5-4 decision, upheld the validity of these class and collective action waivers in arbitration agreements. And it's kind of an odd topic to be discussing in this employment agreement presentation because, by and large, the benefits that a company is going to receive from an arbitration program or a dispute resolution program that requires mutually binding arbitration is going to come from that class and collective action waiver. And the employers that benefit the most are the ones that have the most employees and the largest potential exposure to wage and hour class action. And those employees are typically not employees who have employment agreements. And so it's kind of a different consideration and a different analysis of do we want to implement a dispute resolution program that requires employees to submit to individual binding arbitration, and then kind of the second prong of that, do we want that dispute resolution program to extend to management and executive employees as well as hourly employees typically will not be subject to an employment agreement. One other aspect of the the arbitration agreement landscape is that states are considering or proposing legislation that would prohibit mandatory arbitration in sexual harassment cases. We think that the court's EPIC Systems decision casts some doubt on the enforceability or the validity of such legislation. Obviously, with the Me Too movement, any action that limits an ability to make public any type of sexual harassment claim is a hot button, but I'm not sure those provisions would be enforceable, but certainly something to keep in mind, and particularly if we're talking about executives, and we have an executive who is accused of a sexual harassment claim. I don't think we can rely on a arbitration agreement to successfully protect from the public disclosure of that claim. Then kind of post-termination covenants in general. I mean, historically, the greatest assets of a company were, physical assets, their land, their machinery, things like that. And because of that, restrictions on confidential information or an employee's ability to compete were relatively rare. The court recently cited to Lee Iacocca back in the late 70s as the president of Ford, leaving, going to Chrysler, taking with him most or a large percentage of Ford's leadership, turning around Chrysler from the verge of bankruptcy, and then there was never any litigation around this. I mean, it was simply accepted, and that would never happen today due to kind of the proliferation of non-compete agreements as well as protections of trade secrets and other confidential information, as well as non-solicitation agreements that would restrict a employee's ability to solicit or hire current employees of the company. And these such agreements have as their popularity has increased and they have become more mainstream, they have been faced with more scrutiny by courts. And courts are less willing to enforce, overbroad restrictions. I mean, restrictions on employees for whom, non-compete or non-solicitation or confidentiality provisions really aren't necessary. If someone is simply a hourly employee working in a production facility, courts have been pretty quick to say, like, a non-compete is inappropriate with respect to this individual, where it may have been entirely appropriate with respect to his boss or his boss's boss. Today's workforce is increasingly transient. That, coupled with the ease of electronically storing information, copying information, and transmitting it, and the fact the company's most valuable and skilled employees are typically the ones that have the most mobility, these types of restrictions are becoming increasingly important, and kind of the skill and expertise in drafting these agreements such that they are enforceable and will be enforced in the manner as intended, is kind of becoming more and more important as companies try and protect from this disclosure of confidential information, disclosure of trade secrets, and loss of customer lists and key client accounts. So first we'll talk about trade secrets. And all jurisdictions protect companies' trade secrets through either the Uniform Trade Secrets Act or common law. Considerations determining whether something is a trade secret include the security measures that have been taken by the company. The greater protection the company uses to limit the disclosure of this information, the greater the likelihood that it will be deemed a trade secret. And it's pretty practical stuff, like if information is confidential and a trade secret, is it in a locked file cabinet or is it out in the open that it's accessible to everybody? Is it limited on a need-to-know basis, or can employees who have no business looking at this information still access it? Same thing, the information's value. If we're talking about Coke's secret formula, or we're simply talking about information that while it may have some value, it can be reverse engineered by looking at a map and a phone book and other publicly disclosed information. While the company may have spent some time and some money gathering it, it's not necessarily a trade secret if somebody else with with some work on their end could reproduce it. Effort and creation, same thing. If we're talking about a formula or a business model, if it's something that was years in the making and required a lot of time, money, and commitment from the company to create, that's more likely to receive trade secret status than something that is more easily attainable or could be created with little effort. Same thing, ease of duplication. We've already kind of touched on this, but something that could be easily replicable or easily duplicated by a competitor is likely not going to receive trade secret protection. We already talked about public access and intercompany awareness. Same thing, is this being limited and restricted such that truly only people who need to have this information have access to it, and anyone who does not is on the outside of the wall or somehow shielded from the information to truly protect this important information. Examples of trade secrets can, but not always include customer lists and client information, marketing, development, research plans, novel production techniques, ideas, concepts, discoveries, inventions, manufacturing processes or methods, proprietary software, and it's an area of the law that's difficult to kind of give summary, yes, this is a trade secret, or no, this is not, because literally everything we just talked about, I can cite to a case where this customer list was deemed a trade secret and this other customer list was not deemed a trade secret based on all of the various facts and how that list was generated, how that company treated the list, how they protected it, who had access to it, everything like that. So it's tough to give a yes/no answer. Is this or is it not a trade secret? But some examples of things that are not trade secrets include anything that's not kept a secret, general business knowledge, anything that is the skill or knowledge of a particular employee, anything that's publicly available or kind of general public knowledge, and anything that has been reverse engineered is not going to be considered a trade secret or receive trade secret protection. So an example case is Airfax from late in 2018. In that case, an employee in Maryland sent a particular spreadsheet of his personal email account on his last day of employment, obviously for access to that information after leaving the employ of Airfax. Company sued for misappropriation of its trade secret, and the court held that no misappropriation took place because the spreadsheet was not disclosed to a third party, and there was no proof of harm as a result of this disclosure. Kind of ways the employer could have improved its case is if it would have had a written policy or practice that limited or restricted an employee's ability to use or disclose information via personal email, or something that clearly outlined that employee's obligations at the time of his departure, because the employee's excuse for emailing himself this information was kind of a vague comment that a supervisor had kind of asked him previously if he would be willing to assist in any transition matters that may come up. And so he said, I sent myself this information so that I would have it and be able to assist as necessary. Other ways to kind of strengthen the case are through exit interviews and asking employees at termination whether they have anything in their personal possession or personal email accounts that are company related or that constitute confidential information of the company. Obviously, if they lie there, it really limits their ability to make a argument later that they were doing so for the benefit of the company, and also sets up another level of the protection that the employer uses to restrict access to this confidential information. Then confidentiality agreements, also known as non-disclosure agreements, limit an employee's ability to disclose confidential information. And these are significant because they kind of cover an area of the law where there may be information that is not deemed to be a trade secret, but nonetheless is of significance to the company, and it is in the company's interest to limit its public disclosure. And they also, it's a lot simpler to enforce a written agreement than it is to go persuade a court that information that was disclosed constitutes a trade secret. So enforcing a non-compete or a confidentiality agreement is highly preferable to a company versus trying to restrict a former employee's ability to do something based on a doctrine of inevitable disclosure of a trade secret. With regard to confidentiality agreements, it's important that they be well tailored, they not be overbroad in terms of the scope of what is considered confidential information, or the time period with which this information is protected. Something that is confidential and justifies protection, maybe for a 6-month or 1-year period is appropriate. If we're trying to prevent somebody from disclosing 5-year-old information, more than likely a court is going to find that that information is stale. Whatever benefit the company would receive from its confidentiality is no longer a legitimate concern, and therefore it's an overbroad agreement and may deem it unenforceable. Similarly, with respect to non-compete agreements are the restrictive covenant that is viewed with the most scrutiny by courts. Some jurisdictions simply refuse to enforce them altogether, whereas others are very reluctant to enforce any agreement that contains any provisions that are overbroad, geographic scope, temporal scope, or the subject matter of the restriction. As we said before, they are extremely useful, and it's much easier to enforce a well-drafted confidentiality agreement than it is to try to restrict an employee's ability to compete based on trade secret grounds. A common refrain from judges, if a company has an employee who leaves and that employee is now competing with his or her former employer, the former employer tries to limit his ability to compete based on the argument that he has our trade secrets, inevitably he's going to use those against us. Courts frequently say, look, you had the ability to get him to sign a non-compete. You didn't do it. I'm not now going to essentially enforce a non-compete that the employee never signed based on your alternate argument that he, in all likelihood, will disclose a trade secret. So because of that, it's key that if the jurisdiction permits non-competition agreements, and this is an employee for whom it is of significance that we get one, that we do it either at the time of the employment agreement or as a condition of severance. The non-competes in general, not just courts, but President Obama and numerous states have taken action to either ban them entirely or significantly limit their enforceability. One example, Massachusetts. They had a law that went into effect in late 2018, which non-competes are non-enforceable where the employee is laid off or terminated without cause. So if a company has a non-compete agreement and their employee leaves to go try and work for a competitor, Massachusetts will enforce that non-compete. However, if the company lays off the employee, it can't then say, we are no longer employing you, you don't have a job, but you can't get one with one of our competitors. In addition, the agreement cannot be for more than 1 year and must allow the employee to be paid at least 50% of salary during that restricted period. So again, if you're going to force them to stay out of the market for a period of time, you have to pay them in exchange for that covenant. Other state jurisdictions, restrict non-competes to, only exempt employees, or, require that the restriction be presented, at the time of a formal job offer or 10 days in advance of the start date, and do not, recognize continuing employment as sufficient consideration to support a covenant not to compete. And other states are considering such laws and have them pending at various stages in the bill making process, including Pennsylvania, New Jersey, and New Hampshire. A recent example in NVR versus Nelson, there's a district manager of NVR, also known doing business as Ryan Holmes. It had a non-compete provision which purported to restrict him from working in a restricted area for 12 months after separation of his employment. That restricted area was defined as anywhere where he obtained confidential information from. And when the court applied the facts, it found that ended up being a jurisdiction that included 14 states. And the court ultimately found that was overbroad in scope, and the employer could not enforce a restriction to compete that prevented him from working anywhere in a 14-state geographic region. And this is kind of a key issue here because, some courts have exercised the right to essentially redline an agreement and strike or modify those provisions that the court deems to be inappropriate or unenforceable. However, other courts have adopted an approach where if any aspect of this agreement doesn't pass muster or doesn't meet our requirements, we are simply going to discard the agreement, hold it unenforceable in its entirety, and refuse to enforce even those provisions that we don't have a problem with. Then non-disparagement clauses, as a general idea, pretty easy to understand, either unilaterally or mutually prohibit making of disparaging remarks anytime during the employment or thereafter. Kind of one problematic area goes back to that ability to exercise protected concerted activity under the National Labor Relations Act. And an employee who is complaining and making comments either on social media or within the organization that may be viewed as disparaging, nonetheless may be considered concerted protected activity that cannot be prevented by a non-disparagement agreement. Non-solicitation provisions, very useful again. So a non-solicitation agreement would be a limitation on an employee's ability to solicit or actively seek business from current or potential clients, or to solicit current employees to leave the company to go work for a new business or that individual's new employer. Some key issues, while a court may be inclined to protect against direct solicitation, like the signer of the non-solicitation agreement actively recruiting an employee to come, they're much less inclined to protect against indirect solicitation, or if a current employee is not happy, approaches a former employee who now works for a new company and says, "I'd love to come with you," court's likely not going to allow a non-solicitation agreement to prevent that employee from moving to a place that he wants to go to. And then that brings us to gag clauses, and I'm going to pass it back to Jen.
Okay. Gag clauses are provisions in the agreement that prohibit the person from describing the agreement itself, or just telling people about the existence of the agreement or what benefits they've negotiated in it. And there are lots of state prohibitions on agreements that ban the disclosure of a settlement of sexual harassment claims. So if there is any sexual harassment claim that's part of the agreement or that's being settled as part of the separation, you want to make sure that you've excluded that from the gag clause. And in addition, one of the things that was in the Tax Cut and Jobs Act at the end of 2017 is a provision that eliminates the company's tax deduction for any settlement that's related to a sexual harassment claim if that settlement agreement contains a gag clause. So you need to consider in that case whether you want to divide out the severance amount to say this is the amount that relates to the sexual harassment claim, and this is the amount that relates to the rest of it, so that you can preserve your deduction for the rest of the claim settlement, and you're only losing the deduction for the sexual harassment part. if you have a gag clause. So you want to think about whether you have gag clauses at all, and if you do, you want to parse out the amount that's related to any sexual harassment so that you can preserve the tax deduction that you would otherwise get for the severance benefit. With that, I'm going to open it up to questions, and we have a couple of questions. The first question that we got was on the employee compensation questions. And as a starting rule, that's focusing on base salary expectations or base and bonus expectations. It's not trying to limit your ability to do a negotiation where the person says, I'd love to come and work for you, but I'm leaving this bonus on the table, so I can't come until May, or I can't start right away because I got to stay and get my bonus. And then it starts a negotiation as to, well, we'll give you a hiring bonus that offsets it because we want you to start early or whatever. That's not the kind of comp disclosures that they're focused on. These provisions that they're focused on with the non-disclosure of current comp or your comp with your prior employer is trying to get at that systemic discrimination based on your pay. A second one of the questions that we got in was focused on lump sum payments, or the question I had made about, or I had noted about the ERISA exception for severance pay. And ERISA says amounts that are paid on termination of employment that are paid over a period of more than 2 years or that exceed 2 times pay are retirement pay and are subject to the retirement non-discrimination investing requirements, etc. If it's paid over a period less than 2 years and is less than 2 months or 2 times your pay amount, then it's treated as a welfare benefit and so is exempt from those rules. So if it's a retirement benefit, I may still be able to deal with the lumps, or have a benefit that exceeds the 2 times pay, for example, or is paid over a period longer than 2 years. I may still be able to fit in an ERISA exception as a top hat plan. It's a benefit that only applies to a select group of management or highly compensated employees, but I have to make sure I fit within an ERISA exception. I got a question on how 409 Cap A excise tax process applies. That's really beyond the scope of this. I'll follow up with that questioner offline. And then we got a question that came in on the gag clauses and whether that applies on both sides. Both, can you does the penalty on the tax also apply to the victim of the sexual harassment? And the short answer is that the way that the tax penalty was written, it applies to, there is no deduction on either side. So the amount that the employee pays their lawyer in connection with it, with the negotiating the settlement, that amount is also not deductible by the employee. And you can have gag clauses that are written on both sides so that it prevents the employer from talking about it. If you have a gag clause that's going to restrict the employer, you want to make sure that you've written it in a way that doesn't impede your ability to investigate the alleged sexual harassment, and that can turn into a big problem because for you to do the kind of sexual harassment investigation that you need to do by law, you're going to have to disclose certain information. And Mike, do you have any other nuance to talk about with that? Or
I don't think so. Looks like we've used the hour, so thanks, Jen. That was great.
Thank you for joining us today. We hope that you will also join us again on April 25th for our next program, which will be entitled COBRA Beyond the Basics. Registration information will be sent out soon. Should you have questions after our call, please feel free to reach out to Jen and Mike. This concludes our program.